This program is brought to you by the Reeves Law Firm, representing you and your Social Security and disability needs. If you have a problem or questions regarding Social Security and disability, call Attorney Anthony Reeves, toll free at 1-888-962-0007. Again, that's 1-888-962-0007. Or go to www.reevesfirm.com.
Welcome to another edition of Q&A Social Security Disability Today. My name is Attorney Anthony Reeves. Let's get to your questions. What happens after I leave the hearing? All right, I've actually had this before, but someone wanted me to really go into detail about what happens. Okay, let's take for a second. You've gone to your Social Security Disability hearing. You've gone before the administrative law judge. They've taken your testimony. There's probably been another expert in the room. They've probably said the work that they think somebody like you might be able to do or might not be able to do. The judge says, most judges don't give you a decision right there at the hearing. You walk out the door, the judge is like, have a good day, I'll get a decision to you. Some judges will say, I'll get your decision in about 30 to 40 days. Ooh, it's hammer time. What happens next? First and foremost, let me make this point abundantly clear. Do not put all of your faith into the decision being given to you at the exact time the judge said they did. Let me explain why. A lot of judges, and there's a lot of them, when they tell you that, they're giving you an approximation. But the reality is that if something happens, it may cause a delay. And you're like, well, what could possibly happen? Well, let's say that when you walked out of the hearing, the judge had indicated they're going to review your file. Well, maybe after reviewing your file, they make a determination that maybe you need to be sent for an evaluation. Well, guess what? You're not going to get a decision in 45 days now because they've got to notify the state agency. The agency has to find the doctor for you. They have to schedule your appointment. You have to go to that appointment. You have to, after the appointment, the results of that appointment has to be sent to the Social Security Administration, and then the judge has to determine whether or not he has enough or she has enough to make a decision, or if they need you to come back. All that, and in your mind, you're thinking your decision was going to be rendered in 45 days. Here's what I tell people all the time. When you go in there and you leave, first and foremost, if you have your representative, they'll help you understand this a lot more. But in some instances, if the judge believes there's additional evidence that they need, whether it be you say, well, I'm going to go get these records, or maybe your representative say, oh, there's records that they're outstanding. Can you give us 15 days? Let me brace you for this. That decision will not get started being worked on until that 15 days has passed or those records have been submitted. So let's say you have a judge that says, I'll give you 30 days to get those records. Well, guess what? I hope you're not sitting here thinking the judge has written the decision, and then once they get those 30 days passed, and they're going to just plug in those records and just write your decision. It's not how it works. They're going to leave the record open for 30 days, and they're not going to do anything with that decision until those records come in. So guess what? Your clock hasn't, that 45 days or however long it takes for them to write the decision doesn't run until they get those records or until that period of time ends, or if the representative asks for more time, until that actual end time ends. Now, that may sound confusing. Here's what I mean. Some judges will actually say, I'm going to give you this amount of time. If you need more, let me know. Well, guess what? If the representative thinks that you've got some records that may help you, but they need more time getting them, they're going to ask for that more time. What sucks for you is that it means you've got a longer wait. So if the judge says, I'm going to give you 30 days, and after 30 days, they still haven't gotten the records, then they'll say, can I have another 15? The judge says, yeah, I'll give you another 15. So now it's 45 days. Well, can I have another 15? Now it's 60 days. You finally got the records. Now the judge is going to start working on writing your decision. So 60 days has passed, and you're thinking, well, it's been 60 days. Why haven't we had the decision? Because the judge hasn't started writing it yet. He or she won't start until the record is actually closed. So as long as the record's open, it's going to sit there. So let's go best case scenario. You walked out of the hearing. The judge has told you, I'm going to get a decision out. None but love for you. Sit back and wait. Okay. What can you do? Wait. Let me tell you what you don't do. Don't get on the phone and call Social Security every day. I've had clients who've done that, and I've told them that never works out well. And they say, well, why not? I said, because first of all, they're not going to tell you when the decision is going out. Second of all, there's no guarantee that message is going to get to the judge, because the judge has a lot of claimants that they're writing decisions on. Keep in mind, it's first come, first serve. So guess what? If they've got 50 or 60 decisions per week, or 40 per week, guess what? The one they started first is going to take precedence over yours if you're number 40. So keep that in mind. So what I tell people is this: when you walk out of the hearing, brace yourself. Brace yourself for at least, say, 2 to 6 months. Now, before you freak out, it almost never takes that long. The reason why I tell people 2 to 6 is because there is nothing in the regulations, or at least nothing I have found, that specifically requires the judges to render a decision within a set time period. So there's nothing that mandates they have to give a decision within a set window. So as such, I know some of you are like saying, so what are you trying to say, Attorney Reeves? Are they going to sit on it forever? No, because they understand that you've been there. And trust me, judges are very sensitive to the fact that they know you've been sitting there waiting. You applied 2 years ago and you just got before them. They're not going to drag this thing out. So please don't have it in your mind that that's what they're going to do. However, in the same instance, you need to be aware of the fact that it may take a while. Now, during that time period, they're making their decision, and you're like, well, how can I find out how far along it is? Really, in the grand scheme of things, you can't. The representative can find out whether or not it has been moved from, if they have access to the electronic suite, like a lot of representatives do. If you can tell when you've had the hearing, if you go into the system, you can see if it's been moved from hearing status to post-hearing review or post-hearing development. Post-hearing development usually means they're waiting for additional medical records, or they're thinking about doing some additional other things. Post-hearing review means the judge is reviewing the decision to make a decision, reviewing the file to make a decision. Pending decision writer typically means they've made their decision, they've kind of given the boilerplate, and they've put it in the queue for a decision writer to write it on behalf of the judge. And then once the decision writer gets it, it goes to decision writing mode. That means now there's going to be somebody who literally sits down and writes the decision on your behalf. And this can take a little bit. Okay, that's why I tell people, brace yourself for the window of time that I'm referring to. Now, going from there, you get your decision in the mail. Why is this decision so crucial? It's very crucial for 2 reasons. One, if you get denied, under the law, you're given the opportunity to appeal your decision. However, the only way you can appeal it is to know why they denied you. So you want to be able to have a decision in hand so you can know definitively what the court's reason was for denying you, so that your representative or you can analyze it and make your determination of whether or not you need to appeal the case. If you get approved, this is the document that gets you paid. So keep in mind, you want this written decision, because Social Security, whether it be the local office or the payment center, nothing happens. You see no money until they get this document, because not only does it pay you, it also lays out the parameters of how you get paid. Now you would say, what do you mean by parameters? Well, remember, when you apply for disability benefits, you indicated your disability benefits started on a particular date. Well, depending on how the judge writes the decision, the judge could either agree with you or disagree with you. And what do you mean by disagree with you? You mean I can get paid, but he or she can still disagree with me? Yes. How does that work? Well, let's say that you say you became disabled January 1 of 2010. Well, the judge may say, I think you became disabled January 2011. So you're entitled to benefits. However, it's not the full period that you asked for. Or even differently, the judge may say, yeah, I believe you were disabled January 1, 2010, but I think you medically improved. You're good now. March 1, March 2, March 3, March 4, whatever day it is, 2013. That's a closed period. That means he gave you a lump sum, or she gave you a lump sum, and then basically said you ain't that bad after that. You want to have that decision in front of you because you want to be able to exercise your rights under the law if you want to appeal that decision. Okay? Now, one other tip that I always put out here, because I get this all the time. Do not, I repeat, do not analyze, scrutinize, or hypothesize on whether you got approved or denied based on the amount of time it takes for a decision to come out. I get that all the time. If it takes a long time, people think, oh my God, that means the judge is really, really contemplating whether I'm disabled. I don't know, that may be a bad thing. Or they'll get a quick decision and we got a decision. I look in the system and I see, the decision went out today. Oh man, they made it real fast. That means they must really approve me. And I tell people, don't fall for the okie doke. Don't assume that just because it takes a long time, you're going to get denied. Don't assume just because you get the decision quick, you got approved, and vice versa. Just because you got approved quick doesn't necessarily mean you got a denial quick. Just because you got approved, just because it took a long time doesn't mean necessarily you won't get approved. What I tell people all the time is this. Once you've walked out of that hearing, there's nothing. You've done what you're supposed to do. You got all the medical records in. You've made your legal arguments. You put everything on the floor. All you can do is sit back and wait. And your best bet is sit back and wait. Stay right here, and when we come back, we'll let you know what we're going to cover on our next show. On our next show, we're going to talk about disability reviews as a result of you going back to work. Stay tuned to that because you won't want to miss it. Again, this is Attorney Reeves, and this is your Q&A, Social Security Disability Today.